Without a microphone.
Thank you very much. Hope everybody had a good lunch. Everybody back ready to go? All right. Mr. Mitchell, you got another witness to call?
Christy Turner.
Ma'am, over here.
Raise your right hand. Swear affirm the testimony you'll give for the hearing officer will be the truth, the whole truth, and nothing but the truth, so help you God. All right, would you state and spell your name for the record, please?
Christy Turner, K-R-I-S-T-I-E, Turner, T-U-R-N-E-R.
What's your current, how are you currently employed?
Currently, I'm the Director of Development Services here.
And what, is that a department or is it under another department?
It is a department that encompasses business license, marshals, and building inspections.
And, how long have you been in that position?
Since May 19th.
Where were you prior to May 19th?
Prior to that, I was in the planning department as the principal planner.
And how long were you in the planning department as the principal planner?
Well, I came to Hall County in February of 2024 as the senior planner, and then was promoted into the principal planner. I don't recall the exact date.
Prior to Hall County, where did you work?
Prior to Hall County, I worked in Natrona County, Wyoming, as the county planner.
And, does Wyoming have a similar law to Georgia's Open Meetings Act?
Yes, sir, they do.
What do they call it?
The Public Meetings Act.
To your understanding, are they very similar in the way they operate and what they require?
Yes, sir.
Based on that training and experience that you've had, what was your understanding of what was required by the Open Meetings Act?
So the Meetings Act requires that if you have a quorum, that requires a public meeting, which would require public notice.
In your role as the director in Wyoming, did you have any particular, obligation or duty with regard to compliance there?
It was part of my responsibilities to assure compliance.
When you were working as a planner, did you attend the planning commission meeting for the scheduled ones on the evening of first and third Mondays of the month?
Yes, sir.
We've heard testimony about, pre-meeting sessions that occurred earlier in the day on those Mondays and then the Tuesday before. Did you ever attend any of those?
Yes, sir.
From your perspective, what was the purpose of those meetings?
Those meetings were to generally review the agenda, discuss conditions, and make any modifications.
And to make modifications, what are you talking about with regard to the conditions?
The conditions.
We heard from a previous witness, the staff report was not usually provided when you went, it was only the conditions. Is that consistent with your recollection?
That, I believe so, yes, sir.
So, the agenda that was discussed at these pre-meeting sessions, which agenda was it
The planning commission agenda
for the upcoming
for
meeting?
the upcoming meeting.
These meetings, when was the last time you staffed a planning, or that you attended one of these, pre-meeting sessions?
It was sometime in February of 2025.
during that, when you did go to these meetings, did you work through the entire agenda? The upcoming meeting?
To the best I can recall, we would go through the majority of the agenda items.
When you were attending these meetings, did any of the planning commissioners typically attend?
Yes, sir.
Right. Did some of them attend more often than others, these pre-meeting sessions?
Yes, sir.
Did any of them attend all the time?
So, Commissioner Braswell would attend, and Commissioner Hunt routinely.
Was Commissioner Braswell the chairman when you were in your planning
Yes.
function? Did a third planning commissioner ever show up when Braswell and Hunt were already there?
And there were a couple of occasions that I witnessed that.
And who was that planning commission member that was just a third?
That being Commissioner Sesby.
Tell us about the first time that happened when Hunt and Braswell were there and Sosby showed up.
I believe that the meeting was already, we were already in the meeting, going through the items, when he entered the room.
And was the agenda or any conditions discussed while he was there?
I believe so, yes.
Do you have any recollection of how long that discussion lasted?
I don't, like I said, I believe we had already been meeting and he came in, and I do not recall how long that he was there.
Do you recall whether anybody said anything when he walked in about there being three there, or whether anything happened as a result?
No, sir, as I stated previously, I was waiting for someone else to say something.
Did anyone ever say anything in that particular occasion?
No, sir.
Did you say anything to anyone after that meeting?
Yes, sir.
Who did you talk to?
So I went to my direct supervisor, Ms. Ahmed, and had the discussion.
At that time, she was Greenway.
Yes.
And what did you tell Katie?
Discussed the requirements, and that went against those requirements.
Did you get any impression as to what, if anything, happened as a result of your telling her that?
I was told that she would discuss it with Ms. Garment.
Now, was there a second time that you witnessed a situation where there were already two planning commissioners present, and the third one came in?
There was.
And tell us about what happened in that occasion.
On that occasion, I had determined that if I was put in that position again, that I would excuse myself. That time there happened to be something I needed to be leaving for anyway, and so I just excused myself from that meeting.
Why did you feel that it was necessary to excuse yourself in that circumstance?
It was not something that I wanted to be party to if there were any discussions of business.
And why is that?
Did not want to participate in anything where there was a quorum.
Because it would be illegal for there to be a quorum and not advertised meeting.
Yes, sir.
Especially on those Tuesday before meetings, were the condition, it's my understanding that, at least most recently, we've heard earlier, that there was most of this discussion during those Tuesday before meetings had to do with the conditions, the revising conditions, and y'all would put them up on the screen in that room, and there'd be redlining. Was that consistent with what was going on when you were staffing those meetings?
Yes, sir.
Was there anything else that occurred other than discussion of agenda items and redlining conditions? Do you recall anything else about those meetings, about the Tuesday before meetings?
Generally, that was the goal of those meetings, was to go through and review the agenda items, the cases, give backgrounds, and address conditions.
Were the meetings on the Monday of the advertised planning commission meeting, were those any different different, did it run any different, or was there any different topics in those meetings?
No, sir.
That's all I have, Mr. Turner, was the topic.
Ms. Turner, I'm representing the planning commission. Tony Powell. Does Wyoming have an exception that allows staff meetings to be exempt from the open meetings act?
I'm not aware,
Are you aware that Georgia has
no, sir.
that? Correct me if I'm wrong, Ms. Turner, but you said the first time you were in a meeting where more than, 3 commissioners were present, that, Mr. Sosby wanted in. And that made the third person present.
Yes,
And you're sure about that?
yes,
There's no question in your mind that's what happened.
to the best of my memory.
Do you remember the meeting of September 16th, 2024?
I'm believing that is around the time, that this would have happened.
You don't remember the meeting, but do you?
Specifically, each meeting, they were all generally the same.
Who was at this one?
I don't have notes, and to my recollection, if that's the first meeting that, I attended, that could be the meeting where the 3 commissioners were there.
The record that we have of people being on the floor, but supposedly you went down the hall towards the conference room, to a meeting about 3:26. To go to that staff meeting. You remember that being the time you went?
And those meetings generally happened around that time.
But you don't really remember going to it.
I went into that room many times.
But I'm talking specifically on September 16th, you don't remember that.
To the best of my memory, we entered on the routine basis without a calendar in front of me.
According to the record, you exited at 4:57. You remember exiting at 4:57?
And again, we met routinely in that room.
So you were allegedly in the room at 3:26 according to the cameras. And Mr. Braswell and Mr. Sosby were in the room at 3:33 and 3:58. You recall that?
If that's the meeting that they were there and the cameras show that.
It doesn't sound like, Mr. Sosby came in to make a quorum.
I'm sorry.
Doesn't sound like he came in to make a quorum on September 16th, 2024, because he was already there. And you were in there with him when Mr. Braswell, is that right?
I do not recall the exact.
According to the report, that's what it was. You were in the room, Ms. Greenway was in the room. And Ms. Garman were in the room. And Mr. Braswell was in the room, and Mr. Sosby were in the room from 3:58 until you left the room at 4:57. Do you recall that?
I recall being in a room with them.
It's just really hard to remember the exact details. You know, this is 2 years later, right?
Correct.
Okay, well now let me give you another fact. It was Mr. Hunt who came in at 4:50. Let me say that, let me correct that, that's not right. Mr. Hunt came in the lobby of the third floor at 450, so he had to walk around the corner and then enter the room, everybody say hello, that kind of thing. Do you remember that?
As I said, I'm not 100% able to recall what happened at that meeting.
So the most important thing is you were only in that room with 3 commissioners from 450 to 457. Now, what I want you to do is tell me exactly what those 3 people discussed in that meeting on September 16th. In that 5 to 7 minutes.
I can't state exactly what they discussed in those moments, other than the general, contents of the meetings.
Do you recall the contents of the meeting on November 18th, 2024?
Again, it was it would have been in regards to the agenda items for the upcoming planning commission meeting.
Do you remember who was present who was in the room when you got there?
I do not.
Do you remember, Mr. Braswell and Mr. Sosebee? Mr. Braswell came in at 3:04. Mr. Sosebee came in approximately 4:31. Do you recall those meetings in that meeting?
I do not remember the specifics.
Mr. Hunt came in at 4:33. And you left at 4:34. Do you recall that?
I don't remember the specifics of those meetings.
The most important thing is what was said in that 1-minute period of time while you were in there between these 3 commissioners. That was official formulation, presentation, discussion, action on matters of the planning commission.
I do not recall the exact of the exchange.
Do you recall any of the discussions on April 7th, 2025? Between the 3 commissioners?
No, sir.
You were present on the May 5th, 2025 meeting, according to the camera. You arrived at 3:36. Do you remember the contents of that May 5th, 2025 meeting?
No, sir, I do not.
You exited the meeting at 3:38 according to cameras. So while you were there, it appears that only 2 commissioners were in that meeting. Do you remember that?
I do not recall.
The two members in that meeting did not allow me to open the meeting at that violation.
No,
And so you were not present for any conversation because the other commissioners had arrived last day. Is that what you recall?
I would not have known anybody else would have arrived.
According to the camera, that was the only meetings that you appeared. Do you recall any other meetings that you were in where some open records violation occurred?
I do not.
Anything else, Mr. Mitchell?
The only thing I have, November 18, 2024 meeting that Mr. Powell asked you about, when you left a minute after Stan Hunt, the 3rd commissioner, arrived, is it possible that was the meeting that you excused yourself, you weren't going to be present for a forum?
Yes, sir, it is.
Thank you, man, that's all. Other questions? At this point, I'm going to tender, I'm gonna hand this is the same note that I gave you. I'm gonna hand this to you. I'm gonna tender this document.
Your Honor, we would have exceptions to the note vote.
Exception is noted for the record. Yes, sir.
I mean, it's a remarkable due process violation. The transcripts of interviews that we did not get to participate in. It's really Mr. Mitchell's previous work done without, anybody representing my client in the room. Some of them are taken of my client or clients now, without counsel. And, Your Honor, I just don't think, statements made outside of this hearing without the application of an oath and without cross-examination is pure hearsay formulated that way under those conditions is admissible in any just hearing. And I would object to it.
Thank you, sir. I'm treating this as a public hearing, and I'm gonna allow the presentation of what is going to be presented. That certainly does not mean that I will give, that I will not consider your concerns, that you raised in assigning weight to the various matters.
So, I would tender, as alluded to in the memo that I provided, pre-hearing memo I provided to the hearing officer, I conducted an investigation. So I would tender exhibits 1, 2, 1 is the interview, a transcript of the interview with Chris Braswell. 2 is the interview of a transcript of the interview with Andre Castleberry. 3 is the interview, a transcript of the interview with Shannon Davidson. Exhibit 4 is the transcript of the interview of John Estelle. 5 is the transcript of the interview of Katie Greenway. 6 is the transcript of the interview with Beth Garman. 7 is the transcript of the interview with Stan Hunt. 8 is the transcript of the interview with Zachary Probst. 9 is the transcript of the interview with Barry Shaw. 10 is the transcript of the interview with Frank Victor Sosby. 11 is the transcript of the interview with Christy Turner. 12, I'll get to 12 in a minute. These interviews were conducted at the beginning. You will see when you read the transcripts, if you determine to consider them, I read to them a statement prepared for each one of them. The staff statement was a little bit different than the one read to the planning commissioners. It noted that I had been hired by Hall County to conduct this investigation, and which there's a state statute that says if you're gonna make a statement to someone in their official capacity, you're supposed to be truthful. I didn't administer the oath during these interviews because it was just an investigatory interview. But I think that no indication that any of them were untruthful during that time period. More importantly, this is an administrative hearing. These are records of the investigation that led to this administrative hearing, and I think it's proper to include it in the record. So that's my proffer. There will be exhibit, need to determine a number. Madam Court Reporter, what was the last exhibit that I gave in the 40s? It would have been in the 40s.
I think it would have been 23, and that was the notes, but.
Well, I put in pictures that were
Oh, the picture was the last
41.
one. 41.
Okay, so
There's a 42, the planning commission, or agenda.
So 43 is going to be a flash drive with the audio recordings of these interviews. And then exhibit, I would tender exhibit number 12. That was also gathered during my investigation. Those are, were notes of an interview between Mr. Probst and the Garmin, at the time Greenway and Turner. Number 13 were notes of an interview that were provided to me by Mr. Gentry of the same three. 14, Exhibit 14 is a certified copy of Hall County Code of Ordinances, Section 1-1. 15 is a certified copy of Hall County Code of Ordinances, Section 11.1. Exhibit 16 is a certified copy of Hall County Code of Ordinances, the previous chapter 2.60 of the Unified Development Code. And number 17 is a certified copy of the Hall County Code of Ordinances, Section 2.110.2.11. 19. Then I would tender exhibit 24. This was also documentation I obtained during my investigation. It's a copy of the transcript from the Carl Vinson Institute of Government for Chris Braswell's attendance at Planning and Zoning 101 on June 6, 2019. Exhibit 25 is.
Can we stop just 1 second? There's some of these I'd like to check too, and we're getting out of my memory capacity.
Okay, I'll stop.
So can we just pause for 1 second? The exhibits 14 through 17, those are certified copies of ordinances. I have no objection to those. With regard to the secondhand hearsay of 12, 13, I do object to those. They are just notes made by a third party who's not testified today. And finally, Your Honor, I object to the proposed exhibit 24, which doesn't prove anything. It's a verification that he attended. It doesn't have, I mean, what it's being intended for is to prove that he knows something about, he's been trained in the Open Records Act, and this doesn't prove that. Your Honor, I would also object to the tender of the audio recordings of Mr. Mitchell's out of hearing interviews that were not taken under a flash drive. Exhibit number 43. I would object to that.
Any response, Mr. Mitchell, to those objections?
My response is that, again, my investigation led to this hearing, and these are documents that I gathered during my investigation, and I think properly included in the record, whatever weight the hearing officer desired to give to them.
Well, thank you. Yes, sir, I agree. I mean, they're admitted at a minimum for the limited purpose that Mr. Mitchell just explained. And I understand and appreciate the objection, and discount, yeah, it is according.
Then Exhibit 25 is the Carl Vinson Institute of Government transcript of attendance at Planning and Zoning 101 by Mr. Sosby. And Exhibit 26 is a transcript from the Carl Vinson Institute of Government for attendance at the Planning and Zoning 101 by Stan Hunt. And then I would also add that the flash drive with the recordings, which is Exhibit 43, they are accurate copies of those interviews, the audio of those interviews.
With the objection noted, these are
Your Honor, our objection go 24, 25, too.
noted. And 26, oh. 26 as well.
It was the two, it doesn't appear, he's describing it, well, it says transcript of record, and it's 25 and 26. One being from Mr. Sosby and the other one being from Mr. Hunt.
Yes, sir, I've got it noted, thank you.
At this time, I would call Chris Braswell for cross-examination.
You shall.
Is he still out here?
Chris Braswell to the witness stand, please.
I'm just there in the hallway. Even after an hour and a half of lunch, it doesn't appear Mr. Braswell showed up. I'd call Stan Hunt for purposes of cross-examination. Stan Hunt? I'd call Frank Sosby for purposes of cross-examination. Frank Sosby? Doesn't appear Mr. Sosby in attendance either. I rest your honor.
Right, very much. Understanding your limited appearance, is there any?
No, you're not participating in that one.
All right, very good. Well, with that, happy to hear something like a closing argument, from anybody who wishes to make it. And then we'll, I suspect, I've got some things to review, once it's done. And I would suspect also that I would, request a draft order. Obviously, Mr. Powell, I think yours is going to express your general objections. And I suppose, address the denial of your motion to dismiss at the outset. You're certainly free and welcome to draft an order, at the appropriate time, however you see fit. But I would like both parties to submit, what the order, your proposed orders. But with that, I'm going to ask the county to proceed, with any closing remarks.
County appreciates your attention, and I want to walk through what I think the evidence shows about why there are, open meeting violations that are evident from the testimony, that was provided, here in the room today. But more importantly, and I'll cut to the chase now, we're not here trying to impose any civil penalties against Mr. Braswell, Mr. Hunt, or Mr. Sosby that are one of the penalties allowed under the Open Meetings Act for a violation. We're not seeking any type of criminal prosecution. We're not seeking to have an action, as I said this morning, we're not seeking to have any of their actions set aside, which is another remedy for violation of the Open Meetings Act. What we're contending is, and what I'm asking you to do, is to recommend that they be removed from their position of trust because they violated the Open Meetings Act. There was a quorum of them that gathered together, and and they discussed the business, the heart of the business of the planning commission, which is the planning, the zoning, and the variance issues that were on the upcoming agenda, and the conditions for the approvals of those meetings. We also know that on at least one occasion, they curated how a vote was going to go in one of these meetings. And Katie said that's the way it happened when they went out onto the floor. I want to dispense with the proposed defenses that Mr. Powell has raised this morning. One of the defenses he suggested was good faith, that that's a defense under the Open Meetings Act. Well, good faith is a state of mind. And before this court can have any indication of what the state of mind of these planning commissioners was, they'd have to be here. And they would have to say what their state of mind was, or why they did what they did, or why they took the action that they did, or why they thought it was appropriate for three of them to be in the room, even after Beth Garman said, I can't have three in the room. And sometimes they would obey and comply, but lots of times they didn't. And they stayed, and they would make excuses like, I'm not here, or some joke about somebody's twin brother, which indicates to me, that would suggest to me, and I think it ought to suggest to the court, that they were basically scoffing at the requirements of the Open Meetings Act when it suited their purposes, and they wanted to be in there to either hear the discussion by the other planning commission members, or they wanted to actively participate. And I think the evidence suggests that when there were three of them, just like when there was two of them, that they were actively participating in the conversation and the discussions that were going on with regard to the planning commission's agenda for the upcoming meeting and the conditions that were going to be imposed with regard to the items on those agenda. To me, they have been complaining about the due process issues since the notice of charges went out. Even when you read the interviews, if you choose to read the interviews, you'll see that they were complaining about process even then. And then the opportunity that they have to answer to the notice that they've been given of what the asserted violations are, the opportunity to be heard was today, and they didn't even bother to show up. It's laughable that there's any contention of good faith on their part, and they don't even bother to show up and give this hearing officer in this forum the due respect. Another proposed defense is this investigatory or investigation exception to the Open Meetings Act. That applies when there's a staff meeting held for investigative purposes under duties or responsibilities imposed by law. Well, first of all, if there's a quorum of the commission present, it's not a staff meeting. It's a meeting of an agency as defined by the Open Meetings Act. So it's no longer a staff meeting. If those situations when it was just Mr. Braswell, or just Mr. Braswell and Mr. Hunt, when there were only two of them and one a quorum, maybe those are still staff meetings. But once the quorum shows up, even though there are staff present, then it's no longer a staff meeting, and that exception can't conceivably comply because you're dealing with the actual commission. The actual agency is defined by the law. The other thing is, it's not an investigation. I think the testimony has established that the primary purpose of these Tuesday before and Monday of meetings was to talk through and prepare for the upcoming meeting, walk through the agenda items, walk through the rezoning request and the variances, but most importantly, most of the time was spent dealing with the conditions. And no matter how Mr. Powell tries to shoehorn what was going on in those meetings into some sort of investigation, everything that they did, whether they were asking for the conditions that were applied to a property down the road, or asking for some sort of plat so they could see how the property laid out, or what have you, it was all about how are we gonna draft these conditions. And the conditions that's not investigation. Again, that's the heart of what a planning commission does.
The heart of what the planning commission does is go through an agenda of proposed rezonings and proposed variances and come up with a recommendation to give to the board of commissioners. And part of that, a big part of what they are doing when they're going to recommend approval is what condition, especially in a county like Hall County that's growing the way that it's growing, and they're seeing the type of development activity that they're seeing, the conditions you're gonna put on those approvals to control the impact of that rezoning or the impact of that variance on the neighboring property. The other thing is the Open Meetings Act doesn't define investigation. And, oftentimes the Georgia Court of Appeals or the Georgia Supreme Court, well, when they have to define a term that hasn't been defined in the law, they look to dictionaries, Black's Law Dictionary, Webster's, any number of dictionaries. Well, Black's Law Dictionary defines investigation as the activity of trying to find out the truth about something such as a crime, accident, or historical issue, especially either an authoritative inquiry into certain facts as by a legislative committee or the systematic examination of some intellectual problem or empirical question. It's backwards looking. That's not what these were. These meetings had to do with forward looking. What was gonna be on the agenda either that afternoon or 6 days from then. It wasn't looking back to figure out what had we done or what should we have done. This is looking forward is what ought we to do. And again, that's not investigation, that's going through the agenda and setting the conditions for what's on, what they're supposed to be doing. Webster's dictionary defines investigation or investigate, and of course in investigation, the other noun version of that, to observe or study by close examination and systematic inquiry. Maybe when they were doing the UDC, the one thing, the kind of a contained thing, the Unified Development Code, maybe you call that an investigation. But what we're talking about here, these meetings, it was different every single week. It was a different agenda for the upcoming meeting with multiple items on those agendas. That's not what this particular exception under the Open Meetings Act is intended to excuse. If what they were doing in those pre-meetings could be excused under that, then what they were doing up here could be excused under the same premise, because they were doing the same thing in here that they were doing down there. And in fact, that's what Ms. Garman said, is that she was hardly ever surprised by what happened up here based on what she saw happening down there. That was the whole purpose of those meetings. The other thing is that to the extent there's any investigation in all this, that's been done. When the applicants file the application 60 days before the planning commission meeting, it's to give the staff the opportunity to do the investigation necessary to put together the staff report. The staff report, which is almost never, unless there's a typographical error according to Ms. Garman, ever amended, ever changed, that investigation is distilled into that staff report. And that staff report for that particular item on the agenda has proposed conditions. And that's what these meetings were for. Remember, she told you why these meetings started, especially the Tuesday before, is that there had been a suggestion, well, let's do a work session like the Board of Commissioners does. And as she acknowledged, and I think the local government lawyers that are in this room understand, if it were a work session, then it would have to be advertised. There would have to be an agenda for that. There would have to be minutes taken. Those minutes would have to be approved, and it would be advertised to the public and open to the public. Mr. Braswell didn't want to do that. And so what they did was these pre-meeting sessions where they basically operated like a work session. Oftentimes they managed to not have a quorum there. One, maybe just the chairman, maybe two, maybe the chairman and Mr. Hunt, but at least on some occasions, it was three of them, it was a quorum, and under the Open Meetings Act, that's a meeting. But anyway, the investigation has already been done. That was the staff. That was the staff report. And so these meetings were about discussing the staff report and how that was going to, what that meant for the recommendation that they were going to make to the Board of Commissioners. So I mean, again, good faith is frankly laughable. The application of this investigation, this staff meeting investigation exception, once there's a quorum in the room, it's not a staff meeting anymore. It's a meeting of an agency, and that, they've got to meet the requirements of the Open Meetings Act. The other defenses that have been alluded to, in the questioning, the cross-examination questioning by Mr. Powell is, well, there were no votes at these meetings. Well, all you have to do is read the plain language of the Open Meetings Act to know that voting is only one of the 4 things that happens at a meeting, or that can happen in a meeting that otherwise has to be advertised. If there's presentation that's of facts, or presentation of the matter, the policy, or what have you, that fall within the jurisdiction of the agency, and here, which is the Planning Commission, then that has to be done in a meeting. If there's discussion, and we heard from 3 witnesses, primarily Katie Greenway, now Katie Ahmed, and Beth Garman, that there was all kinds of discussion of the Planning Commission's agenda and the conditions to be imposed on those items on the agenda at these meetings. And that whether there was 1, 2, or 3 there, it was all the same, and it was done the same way. And so when there were 3 there, again, 1 or 2, doesn't meet the requirements. And even when they were doing the Unified Development Code, occasionally when they had to meet with them, they'd make sure there weren't 3 there, and they'd meet with them 2 by 2. That doesn't violate the Open Meetings Act. Once you put a 3rd planning commissioner in the mix, it's a violation. If there was presentation or discussion, and clearly there was. I mean, it's not even disputed. So there was not a vote. That defense doesn't work. The other one that's alluded to in the way he cross-examined the staff was the planning commissioners are not responsible. Well, what they are responsible to do is not to participate in an illegal meeting, which is exactly what they were doing. And here's the thing, they knew it. They knew it. Because first of all, you don't serve in that position for 20 years and not have some clue about what the requirements of the Open Meetings Act are. Especially when you're the chairperson like Mr. Braswell was. When you sit in the chair you're sitting in now with the others there, twice a month in fact, there's an agenda in front of you, and you've got to approve an agenda that has been published and posted. You have to approve the minutes of the previous meeting. If you're gonna go into executive session, which I'm not sure the Planning Commission can do that, there's got to be some sort of reason to do that. They watched the Board of Commissioners meetings. They went through the process with the Unified Development Code. So they knew. But how do we absolutely know that they knew? Because there were times when Beth Garman said, I can't have 3 of you in the room, and one of them would leave. They knew. And sometimes they complied. But on a number of occasions, at least 5 we contend, 7 if you go back to 2024, but I'm focusing on 2025 because that's one that people have the best memory of. There were situations where they didn't leave. 3 of them stayed in the room, and they discussed, received presentations. We walked through with Captain Shaw what the video showed from the elevator lobby. And we walked through the times. You've got the document Exhibit 23 in front of you. The times where there were 3 that arrived on the floor. You've got the pictures where they walk around, and you've seen it's a very small hallway. There's nowhere else for the marshal's office is locked. There's nowhere for them to go other than in that conference room. But what confirms the fact that they were in the conference room is the testimony of the staff. And the staff, also in Captain Shaw's notes, we know which staff members were there, and they're the ones who testified today and said that these three folks were in the meetings, and they were discussing, and they were receiving presentations of the information regarding the planning commissions. And and so we have April 7th, we have May 5th, we have July 21, July 29, August 4, and August 12. When I asked Katie, I interviewed her in October, and I asked her, in the last 6 months, how many times has that happened? Going back to the April, May. And she says 4 or 5, which is it's entirely consistent with what we see from the video evidence of the elevator lobby. What's interesting is also that number is consistent with what Mr. Braswell told me in my interview with him. On page 16 of his transcript, let's start at the bottom of page 15. I asked him, I said, other than that meeting, we were talking about September 15th. You've heard no testimony about the September 15th meeting, even though that's kind of what kicked all this off. Nothing having to do with anything that happened on September 15th. But when you read through the transcripts, you're going to see discussion about September 15th has no bearing on what we're about today. So I said, other than that meeting, have there been times when there's been 3 planning commissioners present where you did discuss conditions, or did discuss properties, did discuss agenda items? Answer, yes. 5, okay. 6, answer, yeah. Question, how often would you say that occurred? Understanding you didn't vote, understanding you didn't make any decisions based on what you just told me, how often did that occur? Answer, well, if we met twice a month, so 24 meetings a year, it could happen anywhere from 3 to 6 times a year, depending on the agenda, and again, we're going by what we do. So, Katie says happened 4 to 5 times in the last 6 months. Mr. Braswell told me during our interview that it probably happened 3 to 6 times in a year. You've got Mr. Shaw's testimony that from April to August, we've got 6 occasions where it happened. What's more troubling about all that, however, is when you look at the dates. In fact, I didn't notice that until I was frankly doing my final prep for talking to you today, is that we've got one in April, we've got one in May, and then 2 meetings in July, and 2 meetings in August. It was accelerating. It was beginning to happen almost every single meeting. And then the Board of Commissioners basically suspended the Planning Commission. I think Katie testified it was in September. So they shut it down. And you heard both Beth and Katie say, started out as just the chairman. Then occasionally Mr. Hunt was showing up. He started coming more often. So what we're seeing from the pattern is there was this pattern where what they should have done is just set up a system where they were having a work session. Apparently they didn't want to do that. So they were doing it this way where they were having quorums show up at these pre-session meetings. And that just simply can't happen under the Open Meetings Act. But more importantly, for our purposes here today, you're not here to find whether or not they're subject to some sort of civil penalty, or there should be some sort of criminal penalty. But does the Board of Commissioners have the authority to tell the Planning Commission, if you're gonna violate one of the most important provisions of state law that apply to what you do, there's not many ways you can get in trouble in local government. I mean, there's lots of immunities and things like that. But if you violate the Open Meetings Act, you violate the Open Records Act, you violate the Conflict and Zoning Act, and I'll talk about why that's important in a minute, then you run afoul. And like Ms. Couch talked about in her opening this morning, we don't have to wait until the Board of Commissioners doesn't have to wait until a Superior Court judge finds that there was an actual violation and there should be some sort of penalty. If they see one of their appointed bodies doing something that's inappropriate, especially when it comes to, I mean, everything that the local government does is important. I'm not suggesting that. But in this situation, we're talking about the Planning Commission, one of the central aspects of the planning and zoning function in a county that's growing quite quickly. And there's a lot of zoning and land use activity. And stuff that's controversial, data centers, multifamily, those types of things. it's critical. And in the cases that are cited in the hearing memo, the Georgia Supreme Court talks about how critical it is that the Open Meetings Act be adhered to, and that the public have access to these discussions. And with regard to this number, when you, again, if you consider the transcripts, I also asked Mr. Hunt, about how many he recalled. And, on page 19 of his transcript, I said, question. Let's go back to the end of page 18, line 25. Question, so are you saying that every time you've been to one of these meetings, it's been 3 planning commissioners present? Answer, no. Question, just occasionally? Answer, occasionally. Question, would you say that it's happened 10 times? Answer, oh God, this may go back many years. Question, let's just go back to January of this year, the last 10 months. It's probably 3 or 4. I don't know. I mean, David Gibbs has video, no? So in other words, we've got Braswell saying 3 to 6. We've got Stan Hunt saying, probably 3 to 4. And we've got Katie saying it was 4 to 5. And then we've got the video when they were actually on the floor at 6. And the numbers all fairly roughly line up when you're talking about people operating from Midway. We've also got Beth Garman's notes that she wrote in her notebook, 2 pages, May 5th and July 29th, which are also dates that we have the video from. And she talked about what the initials mean. You've got those before you. So it's clear that they were engaging in these meetings. They knew what they were doing. The other thing is that whether or not you consider the transcripts that I've tendered into evidence, Ms. Garman testified that there was training that they received from the Carl Vinson Institute of Government with regard to planning and zoning matters. It's the Carl Vinson Institute of Government. Some of this, obviously some of what we put in the video or what have you is circumstantial, but it's also based on direct evidence that you've heard about the violations. But I think that the Carl Vinson Institute of Government, when they're going to train planning commissioners, when they're going to train staff, they're going to train them on what the law requires. So the training would entail zoning procedures law, state law, would entail the Conflict of Interest in Zoning Act, and would include the Open Meetings Act. But whether or not you consider that testimony or the transcripts, to me, the most compelling fact about what they knew was Beth Garman's testimony that sometimes when she raised the fact that there was a quorum present, one of them left, so they'd be in compliance. There were just times, more and more recently, when they just didn't want to be in compliance because they wanted to be in the room and they wanted to talk about the items that were on the agenda. So the defense of not voting, the defense of not responsible, and then the other thing was, and we just talked about that, of, well, I didn't know, I'm not knowing. Well, they did know, and based on their conduct, when Beth would sometimes tell them, clearly indicates that. So, So there's certified copies of section 11.1 in the record. And that's the section that particular section provides for the creation of the planning commission. And the subsection B of 11.1.1 talks about membership, and subsection B says the Board of Commissioners have the authority to remove any member for cause on written charges after a public hearing. This morning, the first thing I did was I handed you a copy of the written charges that's been provided. Mr. Powell of Knowledge Service and those on behalf of his clients. And the other thing was after a public hearing. The other thing that we put into evidence was the notice that this was a public hearing. And they had the opportunity to show up and to be heard and to answer the notice of allegations that had been leveled against them, and they didn't show up. So they've had their opportunity, but more importantly, the Board of Commissioners, through the resolution appointing this hearing officer, providing for notice of those allegations, and providing for this public hearing, have met the requirements under this provision to authorize removal. The other thing that's in the code is, now this appears in the Code of Ethics, and again, this is a whole procedure for ethics violations, but that's not what this is. But what the Ethics Code does say is that no officer, official, or employee shall engage in any activity or transaction that is prohibited by any law which is applicable to him or her by virtue of his or her office or employment, including laws that exist as of the enactment of this chapter, or any laws that may be enacted hereafter. And so clearly the Open Meetings Act is a state law. The Planning Commission, which is an agency as defined by the Open Meetings Act, has to comply with that law. And part of the compliance is you can't have meetings, you can't have discussion, you can't have presentation, certainly can't have votes, and you can't have discussion of policy or other matters within your purview by a quorum unless you have it advertised, unless you have an agenda, unless you post that agenda, and unless you maintain minutes. So that clearly provides for cause to remove them. So in light of everything that you have heard, in light of what and again, whether or not you consider the interviews, you've seen and you've heard enough to come to the conclusion that if nothing else, there were three of them gathering together regularly, especially more recently, talking about agendas, talking about conditions, revising conditions, rewriting conditions, and on at least one occasion during one of these meetings, they curated how the vote was going to go when they came in here in this room and actually conducted themselves in an open meeting. And so I would ask you to so conclude and to recommend to the Board of Commissioners that they remove Chris Braswell, Stan Hunt, and Frank Sosby from the Planning Commission for cause.
Thank you, Mr. Mitchell. Can you address one issue for me?
Sure.
Do I have to find a violation of the Open Meetings Act in order to determine that there's cause to remove?
I think what you have to find is that they engaged in conduct that would have required, that in these meetings that weren't advertised, that they engaged in conduct that should have only happened at an advertised meeting. Whether or not you have to, because I think that the violation of the Open Meetings Act, I mean, if you're going to talk about Mr. Powell's argument, if it was in Superior Court, I mean, there would be a particular burden of proof, what have you. This is an administrative proceeding where the rules of evidence and the burdens are not the same as they are in Superior Court. So if by your question you mean that you would have to find either beyond reasonable doubt, if you're talking about a criminal violation, or by preponderance of the evidence, if you're talking about imposing a civil penalty, I think that you would not have to reach that level. I think that if you conclude, based on the evidence presented, that they engaged in conduct that was not consistent with the Open Meetings Act, then I think that is sufficient to, I mean, if the Board of Commissioners doesn't have to wait till there's an actual violation, and they may run the risk of having a decision that they've made set aside for an actual, found in Superior Court. That's when I say actual, I mean, one that a Superior Court judge finds is a violation of the Open Meetings Act. I think that for your for cause finding that justifies removal, if it appears that they've engaged in conduct that is inconsistent with the Open Meetings Act, that they engaged in, activity that constitutes a meeting when there's been a quorum present and it hasn't met the other obligations, I think that's sufficient. That's the only question. That's all I've got.
I would, just research the jurisdictional arguments that we made at the very beginning, constitutional arguments, I won't repeat those, but do mainly stand on those two. Your Honor's question is really fascinating, when it comes to, okay, what do I have to find? And when you say, oh, I have to find a violation of the Open Meetings Act, it's gotta be in Superior Court. If there's something less than that, and in this case, we got one sentence. It doesn't have a burden. In defending my clients, in this case, Mr. Mitchell argues, it's not the same, it's not Homer's dead, it's not, well, then what is the standard? It's a great question. What's the standard? What pushes us over? Because for cause, in this instance, is defined. And so we're in this vague land of no standards to be applied to circumstances that in the violation accusations are very precisely drawn. If they violated the Open Meetings Act, code section number, and
Can
then
you talk into the microphone? Hello?
I'm getting it. I think.
Are you getting, we can't hear
No,
you. We
I
can't
think-
hear
I
you.
think-
People can't hear
I think
you.
people can hear in the audience.
you want me to talk louder?
No.
Get closer.
Just in the microphone. Thank you.
Okay. The standard is undefined. It's a great question, but the answer being it's less than Superior Court, or it's just you have to show they had 3 people in a room. You know, what is the standard? And there is nothing. I can't point, in this hearing, in this situation, to any standards of evidence or standards of review or standards of definition of what we are doing and trying to prove. It would be very easy if jurisdictionally, Hall County went to the Superior Court and demonstrated as a matter of law there had been a violation of the Open Meetings Act, and then brought it back to this body to remove. Then you wouldn't have to decide that. You could say, is that enough for cause removal? But they've chosen not to do that. They've chosen to try and slip into an area in between that's not guarded by statute of limitations. It's not guarded by good faith principle. It's not guarded by the standards of the exceptions to the Open Meetings Act. It's just, let's show we got 3 people on the 3rd floor so we can get rid of them. And, you know, the statement that we're not seeking any penalties or criminal proceedings, mean what they're really saying is, hey, we're not looking, we want a violation of the Open Meetings Act, but we're not trying to impose the limited penalties of the Open Meetings Act. We want to go further than that. We want to strip 3 men of their vested right and property interest to be in these positions that are given to them by the for cause language in the statute. If there is one, if the only standard, there are 2 standards in the provision that we're operating under. And one is that the public hearing is before the Board of Commissioners. And the second is that it's a for cause right of the individual planning commissioners, meaning they have a vested property interest. You can't just frivolously fire them without demonstrated proof that they have violated something that's required under that for cause standard. They have not violated the Open Meetings Act. And Your Honor, I think the one thing that planning department staff and I agree on is how valuable these staff meetings have been to the process of zoning in Hall County. And how critical they were. They were done at the invitation of the staff. They were done so that investigatory questioning of staff and rewriting of their conditions didn't happen in real time in the middle of a public meeting. But it was not done under cover because the recommendations as they were originally drafted were posted in the public record. And if that were varied, if anything varied from that posted opinions of the planning department, it was done actually in the open meeting that followed. It was the investigative stage where planning staff and these commissioners worked hard together to formulate to take the questions of the planning commissioner, find out from other departments, go out and supplement the information of the applicant. It was all of that investigative stuff that was really valuable. Your Honor, counsel argues that, well, that's what was happening when Mr. Braswell was the only one present. Your Honor, Mr. Braswell present, Mr. Hunt present, is never even a question of whether the Open Meetings Act applies to. They can meet all day, talk all day, it's not a public meeting, it's not a meeting under the definition. The only time you need an exception to the Open Meetings Act is when you have a quorum present. You don't need it before then. And so then, the question is, did the legislature approve an exception? And they sure did. It is an exception to that, all of the requirements of the Open Meetings Act. It says this chapter, meaning the Open Records Act, doesn't apply for staff meetings held for investigative purposes under duties and responsibilities imposed by law. They're just doing their legal responsibility. Everything about those meetings was their legal responsibility. And so they are doing, and staff agrees. Staff agrees to the value. What's interesting to me is that staff said, oh no, nobody's ever told us about the staff exception. And so they got this impression they've done something wrong too, when they haven't. You know, staff is doing their job. Commissioners are doing their job. They're working hard. All of it's in the public purview. You know, the hard part to me of making anything really substantive out of this case is there are no words. You know, there are no formulations. You know, formulation means three commissioners get together and have conversation. It formulates. They make presentations to each other. They discuss, they take action. And open meetings violations that are consequential are when elected officials go into a private meeting and give themselves a raise. There's some case law where it's really clear that people are doing things wrong in avoiding public scrutiny, doing things wrong. It's the words, it's what they did, it's the action, it's what they said, it's how they did it, it's how they formulated. None of these meetings took place without staff being present. Every word that was talked about was done in their presence. And Your Honor, we are only here on the violations that have been proposed and which have been entered into evidence, I think is exhibit 31, 32, and 33. And those are time periods that have some very precise parameters. And the times are, Your Honor, September 16th, 2024. We have a lot of inartful questions about what these meeting presentations were about. They're about agendas, they're about business, they're going over the agenda, they're editing these things. We have some, now what's important to note about those meetings, you know, September the 16th, 2024, is, not that they went over those things. It's what did they discuss with 3 commissioners in the room. And that would, and this only becomes an issue if the staff meeting was held for investigative purposes. It's not an issue. If the exception applies, this is not even a question to be asked. But if we get down to a situation where we don't think it was a staff meeting for investigative purposes, what's the word? The question becomes, in every accusation, there are 11 for each commissioner in those exhibits. For the day, which is September the 16th, 2024, it's what did they, what statements were put in that were a formulation, a presentation, a discussion, or an action. There were 3 staff members, and nobody could tell you what was said while the 3 commissioners were in the room. And I mean, that's undisputed. That's undisputed, Your Honor. They could tell you generally what we talked about in all those meetings, but that's not the question. The question is what was said, what was formulated, what was presented, what was discussed while they were in the room. Nobody can remember. There is a great protection for that kind of confusion, and it's called a 3-month statute of limitations. Because when we're a year later, nobody remembers. Nobody remembers what was said, what was formulated, and nobody is putting on the record in this, there was something that was done that was harmful to Hall County, its citizens. The only thing we've heard from the staff of Hall County is how hardworking these guys are, how they worked beyond the call to come to extra times to formulate their conditions and get information from staff to do their job. And to go into the meeting prepared and ready and with what they thought was the best action to take. But without that specific trial-worthy proof of a conversation, a presentation, and this record is void of it. There's a lot of questions about, yeah, they were talking about it, but there's no, but the refined accusation is to look at Mr. Hunt on September the 16th, 2024, and say, when he was in the room, what is the conversation that created the violation? What did the staff say? And I was very careful, Your Honor, to go to each date and say, what do you remember? I don't remember. The hard part of this was Ms. Turner. Ms. Turner is a kind person, and she's just doing her best. But she described a sequence of events over a year ago where Mr. Susby came in the room. It didn't happen that way. And when I asked her about that, she said, oh no, I don't remember it being the way the cameras show the meeting took place. And it was that with all of those. And by the time we got through with that cross-examination, it was clear she couldn't remember any of those meetings really. And then when I came back through and said, do you know when these commissioners were all there, what was, I mean, it was an honest response. And she shouldn't be in that position because she didn't do anything wrong. Commissioners didn't do anything wrong. They were just, there is no intended violation. Everything here is not just done in good faith. It's a great effort on behalf of on behalf of Hall County to really formulate conditions and do the planning commission work with expertise of planning through staff meetings and results that are really, Your Honor, exceptional. So we should be able to put our fingers on words. Now, Your Honor, I didn't stop with the meeting on the 16th. I purposefully made that inquiry on the 18th, 7th, the 5th, the 5th of May, July 21st, July 29th, August 4th, and August 12th. And there was no recollection of any conversations during the time period when three commissioners were in the room with any precision. Your Honor should know that you can't even determine that from the third-party transcripts. Because if it was in the third-party transcripts, Mr. Mitchell would have put it in the accusations and violations. The fact that it is not in the violations is an unconstitutional imposition on my clients of having to be here without knowing what they're accused of doing wrong. It's a missing link. You don't have an open meetings violation with three commissioners on the third floor, or even if they're in that conference room. There's got to be that next step. It's the statutory language of an open records violation, and that language is there has to be a presentation, a formulation, a discussion, or an action in addition to a quorum. The meeting we didn't talk about that really triggered all of the furor that is going on now is September the 15th, 2025. There's a record showing the commissioners all on the third floor. There was a commissioner who saw them go into the conference room and went into the conference room after them. And they weren't talking about the county business. And they never talked about the county business. And so it went right. Your Honor now has all of these, some of them are undated and unknown dates, and you know, nobody knows if they were even at that meeting. With the ones that are referenced as sometime in February, March 2025, or one or more Tuesdays, those accusations, they don't even know the date. They don't know what was said, and nobody on the staff can identify those. But there is no record of, in any of those dates, of what is required as the second part of the open meetings violation. Not even considering the exception for staff. I don't usually do closing arguments, say something good about counsel. Usually by this time I'm sort of upset with them, but all of this was obvious in the original investigation. And Mr. Mitchell, in his report, said everybody needs to get educated. He was dead on the money. And that was really the conclusion of his investigation was, you know, staff doesn't know the rules, they don't know the exceptions, they don't know the rules. It's critical. The chairman can't stop the planning staff from advertising a work session. They can't do that. And staff who does all of the things that are listed in every violation, call the meeting, advertise the meeting, host the meeting, publish the meeting, do the minutes for the meeting, and do that every time. It doesn't hurt the planning commissioners, doesn't cause any furor. They can do it in the conference room. It's a simple step. Needed some education. You know, I don't think they violated the rules, but even if they thought they might have, and everybody here, you know, we know the Open Meetings Act. We deal with it every day. And we know that the solution is post it. And it's simple. Same thing they did for the other meeting, just post it every time. You don't go 2 years thinking you're violating the Open Meetings Act as a staff and not post it. You know, you just don't do that. But that's not the planning commissioner's responsibility. And I don't think that was done intentionally on staff's part, but I also don't think planning commissioners ought to be removed for not doing staff's job for them. And, Your Honor, that was a right recommendation from Mr. Mitchell. And everybody needs to get educated. These are good guys. They are good guys who have worked for this county for 42 years. This is the first time we've been in a hearing on their part on open meetings. They may have gone to a course, I don't know what was on that course. Record that Your Honor been given doesn't show what was on the course. So I know that's not adequate. So some education would be great. I think it'd be good for everybody to know what the rules are and it's right and wrong. I don't think there's a wrong here. I think there's some hard work on the commissioner's part, beyond the call. And I would encourage, in this sort of wild, wild west standards, that we lean to the favor of those people who have done 42 years worth of hard work. Thank you, sir. Thank you.
Unfortunately, on this record, we don't know what they've done or why they've done it, because they're not here. There is most of what Mr. Powell said about why they did it, what they did, there's no evidence of that. What the evidence in the record is it wasn't just that there were 3 members of the planning commission in a room. We know that. We saw them go around the corner when they got off the elevator. And we know that there were 3 of them that were in that conference room based on what the staff told you. And we know that what they were doing in that room was talking about the agenda and talking about the conditions of zoning that were going to be applied. He suggested that there was no reason for these particular meetings to be advertised. I actually do training, and I have done training for Gwinnett County's Planning Commission and their Board of Zoning Appeals. And I would never recommend that they do what these folks were doing in that room without having it posted, without having it advertised, and without their minutes being done and published. Because it is an important part of the planning function, what the Planning Commission does. It's the first real public hearing and opportunity for public input, and the public was completely excluded from these opportunities. Now, if they're trying to do it where it's only 1 or 2, that's fine. But when there's a quorum present for these meetings, that's a problem, because the public's being excluded from that process. And if they were going to do it, then they should have just incorporated a work session. But as Beth Garman told you, the chairperson didn't want to do that, because it would have required advertising, and it would have required them to come in here and do all this that they were doing in front of the public, and they didn't want to do that. So they did it, increasingly so, in the way that you've heard the testimony here. You asked me what the standard was. Frankly, even if the standard is beyond by preponderance of the evidence, we've met it to show that there has been violations of the Open Meetings Act. Mr. Powell wants there to be some sort of indication of what the actual discussion was. Well, you know what? If these have been actual meetings with minutes, then perhaps we might have that discussion which the public would be entitled to hear about. But we don't have that, because they chose not to do that. They chose to circumvent the requirements of the Open Meetings Act. But what we do know is what a meeting is a gathering of a quorum. There is no dispute, undisputed evidence from the staff testimony that there was a gathering of the quorum of a committee of members of the governing body, which the Planning Commission is. It's an agency, and which any official business, policy, or public matter of the committee is formulated, presented, discussed, or voted upon. There was the official business of the Planning Commission and the public matters that were on those agendas that they ultimately came in here and made recommendations on were presented and discussed in those meetings. Mr. Powell keeps wanting to tell you that this was some sort of investigation. That's not what was going on in that room. What was going on in that room was the discussion about what was gonna happen in this room when they came up here. And it got to the point where even Beth Garment could predict what was gonna happen in here because they were basically crafting it down there. And that's absolutely what cannot happen under the Open Meetings Act. What the Supreme Court has said, what the Georgia Court of Appeals has said, is that we, being that court, have previously observed that the Open Meetings Act seeks to eliminate closed meetings which engender in the public people a distrust of its officials who are clothed with the power to act in their name. To further this purpose, the act, including its default position that meetings be open, must be construed broadly, and any exception to the act, including those pertaining to closed meetings, must be narrowly construed. So, to the extent they want to rely on this investigation exception, what the Georgia Court of Appeals has said, and the Georgia Supreme Court in the Athens Observer case says the same thing. You've got to construe those narrowly. So if there's any argument that this was not an investigation meeting, then you conclude that it wasn't an investigation meeting and the requirements of the Open Meeting Act applies. In order for there to be cause to remove these particular public officials from their position of public trust for violating the law, you've only got to find that they did it once. And there is overwhelming evidence that it was done more than once. There's overwhelming evidence that they engaged in discussions and presentations of the policy of the Planning Commission. The condition that every single staff member that testified talked about, rewriting the conditions, revising the conditions, and importantly, oftentimes, that wasn't done in public. That was done in private. That was done in that conference room. And that's exactly the kind of thing that needs to be discussed in public, and it wasn't. And that's why, to that extent, when the quorum is doing that, that's a violation. In addition to which, there is undisputed evidence. They didn't show up to dispute anything that staff was saying. Undisputed evidence that not only was there discussion of conditions, not only was there discussion of the agendas, but there was one situation witnessed by staff member, who knows how many times it actually happened, where the actual vote that was gonna happen in here was curated down in that room. And that clearly is not investigation. It clearly cannot happen without meeting the requirements, without violating the requirement of the Open Meetings Act. And again, the fact that they didn't show up, I mean, all the evidence for this body is that not only were there 3 members in the room, but on a new number of occasions, but that those 3 members of the body in the room were talking about the business of that body, which were the agenda and the conditions. They didn't come in here to say we weren't doing that. They didn't come in here to say that when there were 3 of us in the room, we weren't talking about anything. Staff says they were talking about matters regarding the agenda, matters talking with regard to the conditions. And again, all of the stuff that they were doing in there with regard to the rewrites and the revisions, none of that was provided to the public. The concept that this was a staff-created situation is not consistent with the evidence. Both Beth Garment and Katie Greenway, now Ahmed testified, they sent the invites for these meetings to Chairman Braswell. Braswell is the one that decided that he was going to invite Stan Hunt and Frank Sosby to these meetings. The staff members were never told beforehand that there were going to be 3 of them there, where they could have advertised it, where they could have posted an agenda, where they could have been planned to take minutes. They found out when it was going on. And Beth Garment said, we can't have this, and sometimes they obeyed because they knew what the law was, but many times they didn't. And we've heard the testimony, undisputed testimony, about the fact that happened and how many times that it happened. This defense that this was just investigation, one of the things that you're going to see when you read the transcripts is that Mr. Braswell never at any point in my interview did he say that these were investigatory. Mr. Sosby never said that it was investigatory. That Mr. Hunt never said it was investigatory. Any mention of investigation in those transcripts are or when I read my statement to them at the beginning, telling them that I was doing an investigation. So, again, it was nice for them to be here, so they could tell you that, yeah, we consider this an investigation. And what the testimony from the witness stand has been, it wasn't an investigation, it was a discussion of the agenda, it was a discussion of condition, it was basically a rehearsal of preparation down there, outside the presence of the public, for what they were gonna do up here. With regard to the staff responsibility, you heard Ms. Garman say she no longer works for Hall County, that she resigned, but it was a resignation in lieu, and she had to resign in lieu of termination as a result of what was concluded by this investigation. So, and again, remember, it's this attempt to deflect responsibility for what was going on. Their responsibility is not to participate in a meeting that doesn't comply with the Open Meetings Act. Whether or not they were responsible for posting the agenda, whether or not they were responsible for posting the notice, whether or not they were responsible for taking the minutes, absolutely beside the point. What their responsibility was not to participate in a meeting that they knew was not consistent, was not compliant with the Open Meetings Act. And if they knew it wasn't compliant, because as Garmin had said, I can't have three of you here when we're doing this, and then sometimes they left, and sometimes they did not. Again, really at the end of the day, it goes back to what the court had said about the Open Meetings Act and its interpretation. It's broadly construed, the requirements, any exceptions are narrowly construed, and it's all about public trust. And it's all about making it so that when public servants, when persons who are in positions of public trust are engaged in the public business, such as talking about agenda items with rezoning, where they're changing the use of land, or providing variances where it's gonna change the use of land, and they're imposing conditions, that those things are done in public, so the public can see what's going on and participate, because that's what inures to trust by the people in their government. When you have this kind of thing going on, what you've heard the staff talk about what's going on in this meeting, that completely undermines the public trust. I think the Board of Commissioners, when you've got that kind of thing going on, that creates the cause for removal of these planning commissioners who engaged in that conduct. We don't have to have the actual words that they said, or the actual things that they did, although we do have some of that evidence through Katie's testimony. What the Open Meetings Act says is you can't have presentations and you can't have discussions of the public matter when you got a quorum present. And undisputed evidence is that there was discussion and there was presentation when there was a quorum present. And they knew it, they disregarded the warnings to stop it, and as a result, we are here, and I would ask you to recommend removal of Ms. Braswell, Stan Hunt, and Sosby from the Hall County Planning Commission.
Thank you, Mr. Miller. Could we just have 2 minutes of discourse about the issue of how you talked about the for-cause standard triggering a property interest vested right. office, is there authority for that proposition, or could you?
Yes, sir, yeah, I can provide that to you. That's really what that word is designed to do, takes you out of, from, at will into for cause, invested property right.
Right, well, certainly in an employment situation, but is there not a distinction because we're talking about an appointed office?
I don't think that word is different for that. And just so you know, the commissioners were so happy with my clients last January that they're actually salaried. You know,
Excuse me,
they're.
that they actually,
Oh,
you can speak from there, just speak louder.
oh, they're actually salaried. I mean, they put them in a different, status, of position. So I think the for cause in this case is, I'll be glad to provide the court with cases
That would be
that
helpful.
demonstrate that.
Well, Your Honor, if I may be heard on that,
Absolutely.
even if you assume that they do have a vested right, which we're not conceding that point, but even if they do, the law is absolutely clear that all they are entitled to is notice and an opportunity to be heard. They certainly got the notice, today was their opportunity. So, from that perspective, again, even if you assume what Mr. Powell says is true, they've gotten their due process today, they've just chosen to not take advantage of it.
Thank you. All right, I'm going to have to take the matter under advisement. I think, I will reach out to the parties to the extent that I need a draft of any segment of my report and recommendation to the Board of Commissioners. But I think I'll give it the first try, and we'll issue a ruling as quickly as possible. Is there, from the county's perspective, an anticipated time frame within which they need a response?
The county's next voting meeting is January 8th. The next voting meeting is January 8th. There's a preference to have something before then that they can consider. But the next meeting is 2 weeks later on the 22nd.
It will be my goal to have the report recommendation certainly out to the parties by the end of this calendar year. So we'll try to do it within this month.
Did I understand you correctly? You do not want proposed orders from us?
I am happy for you to submit, for either of you to submit a proposed order. I'm not imposing that on either of them. Anything else to come before this tribunal before we adjourn? No, hearing none. I think the matter is over. Thank you both for thank you all for your presentations.
Do you want a copy of the transcript or do you do?
And the court reporter has a question, if you don't mind. The exhibits that you tendered to the hearing officer,
We're gonna collect them.
but I thought he needed them to review for his decision.
This is a duplicate book, right?
I've got another copy, that doesn't have everything in it though. That's why I said we're gonna have to assemble all of the exhibits and make provision to give you a copy and the court reporter a copy.
I don't need to leave here with exhibits.
We'll get it, before we leave. we'll-
But, I mean, if you have it done by the end of the year, I'd like it sooner.
You'll have it today or tomorrow.
Very good, thank you.
Can I have the copies we gave you, so we make sure we have them all compiled?
Mr. Mitchell, may I just ask you this question? So 1920, you were going to take out of the notebook, do you remember from Ms. Garland, I believe, was that?
The copies are in there.
Okay.
The copies of those